I want to begin with the question of the whole witness statements and the calling of witnesses. Honorable Chair, it is our application that you decline any request on the part of the mover to call as a witness any person whose either affidavit or sworn statement was not part of the motion before you. The reason we say that is two matters of principle. Number one, you are here to investigate the motion as approved by the House. This committee has no power to interrogate any other material that was not before the House. The second reason of principle, Honorable Chair, is a question of fair trial. When this motion was approved and served upon the Honorable Cabinet Secretary, he was required to respond to the motion as placed before the House, as approved by the House. And now we are being told of endeavors to introduce additional material that he has not had the opportunity to read, to review, and to respond to. This matter, Honorable Chair, is not just a procedural issue. It is a question of fundamental justice that is governed by a whole regime of 5 different sets of laws. The first one being our Constitution, the second being the Fair Administrative Action Act, the third being the prevailing case law on this specific matter we are placing before you, the fourth being your standing orders, and the fifth being the rules of this committee itself. And it is our submission, as I hopefully show you shortly. Whichever of these regimes of law, and I've mentioned them in their hierarchy, whichever of them you look at, there is zero room for introducing extraneous material that was not part of the documents that were before the House when it appointed this committee. We will begin with the Constitution, Honorable Chair and members. Article 50 of our Constitution has a right called fair trial. This right, Honorable Chair, includes, among other things, the right to confront and to respond, and more importantly, when you read Article 50, subparagraph 2J, the right to have the information and the allegations and the evidence against you in advance. Those are not my words. It is the words of our Constitution. The evidence must be submitted in advance so that, as a matter of fair trial, the person accused will have the opportunity to respond to all the allegations against him. This matter of fair trial is so important, Honorable Chair. It is one of the 3 rights in our Constitution that are absolute, which means they cannot be limited. This can be confirmed from Article 25 of our Constitution. It lists certain fundamental rights which cannot be limited. Not even Parliament can enact a law to limit those rights, and one of them is the right to a fair trial. This right is as old, Honorable Chair, given the type of legal system we have. It is as old as the year 1215, more than 800 years ago, when we had a document called the Magna Carta. Article 47 of our Constitution again talks about the right to a fair administrative action. I only mention this, Honorable Chair, because the communication from the Speaker to this committee said a number of things. One of them, of course, was that these proceedings are quasi-judicial, but for purposes of my submission, the Speaker also said in his communication to the House that the proceedings before you are governed by the Fair Administrative Action Act, which is the one that governs this whole question of fair procedure and whatnot. That brings me to the prevailing case law on this matter, Honorable Chair. Luckily, we are not bringing to you a matter that is new. This matter has preoccupied our country to a level that we had to appoint a 5-judge bench of the High Court sometime in 2015 when the Republic of Kenya at that time, beset with terrorist attacks, wanted to change the law on inquiries and criminal proceedings so as to tinker with this right to fair trial so that the state could go to a court of law and introduce the evidence right at the eve of the trial, right at the very 11th hour. And we have a decision, I believe, petition number 628 of the year 2014. I said it's a 5-judge bench decision. And the issue in that case, which likely my senior, Dr. Kamino, was actually the one arguing this point, and the court was happy to agree with him, that it is not permissible, even when the country is faced with existential threats like terrorism, you cannot do what the move of the motion now is attempting to do, which is to bring a motion to the House, have the motion approved by the House, sent to the committee, and then...
Madam Chair.
If indeed the minister is innocent, why is he worried about the witnesses? This is a matter of national interest, as my lawyer has said. If indeed you are innocent, Kenyans want to know. Could be someone is trying to bring witch hunt to the minister. Let us be allowed to bring each and everybody who will set him free. The jury is in the public. When a minister, relax. Let Kenyans...